All right, everyone, welcome. Today we're diving into two really key pillars of intellectual property law: trademarks and industrial designs. We're going to break down what they are, why they're so incredibly important for businesses, and, of course, how they're protected under Indian law. If you've ever wondered how a brand like Nike protects its swoosh, or how a company can literally own the unique look of its product, then you are in exactly the right place. So let's get started. So to get our minds warmed up, let's start with a question. Think about a brand name, say Coca-Cola. Then picture its iconic logo, and then even the unique contoured shape of its glass bottle. What's the common thread here? Well, they are all incredibly powerful, legally protected assets that basically define a brand's entire identity. They're all, in short, crucial forms of intellectual property. So here's our game plan for today. First, we're going to get right into trademarks, what they are, how you protect them, and then we'll unpack the critical difference between infringement and passing off. It's a big one. Then we'll shift gears and explore the world of industrial designs, looking at what actually makes a design unique and, of course, how you protect it. Let's jump right in.
Okay, so first things first, what exactly is a trademark? The easiest way to think about it is as the very heart of a brand's identity. It's how a business shouts from the rooftops, "This is us. This is what we stand for," in what is, let's face it, a very crowded marketplace.
Now, the law gives us a pretty clear definition. Under the Trademarks Act, a trademark is any mark that you can represent graphically. Write it down, draw it, and, this is key, it has to be able to distinguish your goods or services from everyone else's. So the two big takeaways here are graphical representation and distinctiveness. It has to be unique to you. So what can actually be a trademark? Well, you've got your conventional marks, the ones we all think of first. Words, logos, maybe a catchy slogan. But the law goes way beyond that and also protects what we call non-conventional marks. This can include the unique shape of a product, its packaging, which has a cool name, trade dress, and even specific combinations of colors. And of course, in this day and age, that protection extends to the digital world, covering things like internet domain names. And this is where things get really interesting, seeing how the law has had to adapt. In this landmark case, Yahoo Inc. versus Akash Arora, the Delhi High Court made a huge ruling. It said that a domain name isn't just some web address. It functions just like a trademark online, and because of that, it deserves the same kind of legal protection. This was an absolutely crucial step in protecting brands in the digital age.
Okay, so you have a distinctive mark for your brand. That's great. But how do you actually protect it? And that brings us right to Section 2. We're going to look at how you take that great idea and transform it into a legally enforceable asset. And the key is registration.
Now, the path to getting a registered trademark in India isn't instant. It involves 5 key steps. It all starts with filing an application. From there, the registrar examines it to make sure it follows all the rules. If it passes muster, it gets published in the Trademarks Journal. Why? To give other people a chance to oppose it if they think it's too similar to theirs. If there are no successful oppositions, then boom, your mark becomes officially registered and you get that all-important certificate. And why on earth would you go through that whole process? Because registration gives you an incredibly powerful set of rights. You get the exclusive right to use that mark. You get the right to sue for infringement. You can even sell it or license it to others. And this protection lasts for 10 years and, get this, can be renewed indefinitely. It is a powerful, powerful shield for your brand. This brings us to our next section, and it's a big one: infringement versus passing off. Now, this is a really crucial and, let's be honest, often confusing area of trademark law. It covers the 2 main ways you can take legal action when you think someone is misusing your mark. Before we get into all the details, I want you to remember one single point. Just one thing: the entire fundamental difference between a lawsuit for infringement and a lawsuit for passing off, it all comes down to one word: registration. Whether your trademark is officially registered or not determines which legal path you can even take. And this table here really clarifies the difference perfectly. See, infringement is a statutory remedy. That means it comes directly from the Trademarks Act, and for that, registration is absolutely essential. Passing off, on the other hand, is a common law remedy. Registration is totally irrelevant. Instead, what you have to prove is prior use and that you've built up goodwill. They protect different things and are pursued under completely different laws. So let's say you don't have a registered mark. How in the world do you win a passing off case? Well, this landmark case, Reckitt and Coleman, established what we now call the classic Trinity test. You have to prove three things to the court. First, you've established goodwill or reputation with your mark. Second, that the other guy made a misrepresentation that is likely to confuse the public. And third, that you have suffered or are likely to suffer damage because of it. All right, let's totally shift our focus. We've been talking about a brand's identity, its name, its logo. Now, let's talk about a product's appearance. This brings us to Section 4, what is an industrial design? Here, we're not protecting a name or a slogan, but the aesthetic look and feel of an actual item. The Designs Act of 2000 defines a design as the visual features of a product. We're talking its shape, its pattern, its ornamentation. The key phrase to remember here is that these features are judged solely by the eye. We are not talking about how a product works or what it does, but simply how it looks. It is all about aesthetics. But hold on, not just any design can be protected. To be registrable, a design has to meet several really important criteria. It must be new or original. It can't have been published or shown to the public before you apply for registration. It has to be applied to a physical article and be visually distinct from designs that are already out there. And, importantly, it can't be a trademark or an artistic work because those are covered by different laws entirely. And finally, that leads us to our last section, protecting your design. So you've put in the work, you've created a unique and original design. How do you secure the legal rights to it and stop others from just copying your visual creation? So very similar to trademarks, registering your design gives you a whole set of powerful rights. You get the exclusive right to apply that design to your products. You can license it out to others. And crucially, you can take legal action for what's called piracy of design, which is basically just suing for infringement. And you can claim damages if someone rips off your work. Now, before we conclude, this is a really vital distinction to remember. It's a common point of confusion. Design rights protect the aesthetic appearance of a functional product. Copyright, on the other hand, protects original artistic works, like a painting or a sculpture. And while they can sometimes seem to overlap, they are legally distinct forms of intellectual property with very different rules and protections.
So there we have it. We've covered the essentials of both trademarks and industrial designs, from what they are to how they're protected. But I want to leave you with one final thought to chew on. We've been talking about the laws here in India, but in a world where a brand's logo or a product's design can be seen all over the globe in an instant, are national laws really enough to protect them? It's a huge, complex challenge for IP lawyers today. Thanks for joining me.